and thank you to our witnesses. I have to just state this hair on fire outrage by our Democratic friends over a successful businessman giving his time away from his business, I might add, to look at the books of the federal government to identify waste, fraud, abuse, and inefficiencies is some sort of a crime, while Mr. Ring's bank has never met a regulator that has a business background or a banking background. The irony is really quite rich. I think we should have a few more business people looking at our federal books. That said, thank you all for being here. My main interest in the debanking discussion, and I'm interested in all of it, and I think both sides have brought up a lot of interesting issues, but it's not so much the individual that I'm interested in, or even the individual company, but rather the categorical discrimination against large swaths of businesses, entire industries of businesses, constitutionally protected industries, legal industries. I find frightening, and I just want to reconcile, at least in my own mind, the different answers that the three of you gave to Senator Kennedy about which came first. Is this a problem with the regulators, or is this a problem with the bank presidents? To which I'd say yes. The precursor to the regulators, quite honestly, and the regulations, the precursor to this whole debanking thing was this bizarro ESG movement in corporate America. And that was happening before the regulators thought, hot dog, we got another issue we can shove at these guys. So whether it's, I've talked to many of the bank presidents who very much support the legislation that me and 40 of my closest friends so far have introduced, the Fair Access to Banking Act, which doesn't require, by the way, a bank to do anything, but it does prohibit them from categorically discriminating against legal industries. And the reason some of the bank presidents who have never dared say it out loud tell me they support it is because they want this burden removed from them. They want this political pressure from their 30-year-old staff or the regulator that they fear, or the political movement of the day, or the activist investors that are trying to impose their values. They want that removed from them. I'm just saying, let's not discriminate against large industry. And so I guess I would just ask each of you, what's your sense of a bill like a Fair Access to Banking Act that, again, doesn't require anybody, it's not saying you have to bank this industry. It says you're prohibited from discriminating against this. Does this seem like a radical idea?
Well, if I could go first.
Sure.
I think the regulators have pushed debanking of industries, which you're talking about. I think mid-level executives push debanking of individuals for political causes.
Sure.
And my worry is, Senator, with a good intention bill like that, you'd have to prove somehow that we followed the law. And so every time a relationship didn't work out, there would have to be some type of reporting. And so I actually respectfully think the free market is always the best way to solve these problems. And with more banks, let banks bank who they want. If a pro-life bank wants to exist and not bank Planned Parenthood, let them, because there's a bank that would love to bank Planned Parenthood.
Well, if you're good, but if you're going to discriminate against large industries, should you be able to be insured by the federal government?
Well, that's a great question, because what's unfortunate is the regulators were doing this through policies and guidelines, as we've already talked about. Like, digest those, FIL 1622 and SAB 121, and that is how you stop it, is holding those individual regulators accountable, I feel.
Mr. Gannon.
Yeah, Senator, if I could respond to that by simply saying that what needs to be done, consistent with the act that you have introduced, is simply that there's more transparency,
yes,
and there's more notice,
yes,
when these kinds of decisions are made. And one of there's been a long sort of volume of executive orders coming out of the White House, but one of them revived an executive order from 2019 called 13892.
Mm-hmm.
That executive order gives more due process to folks who wish to contest the actions of regulators than the due process clause itself allows.
Well, maybe a law that puts that in statute would be better.
Correct.
My time's up, Mr. Chairman.
Thank you, Senator Cramer.
Thank you both.